Right, to discuss reforms in the judiciary, we're joined by Justice Isaq Bello, former Chief Judge of the Federal Capital Territory High Court. Thank you so much for joining us. It's a delight to have you on Newsnight tonight. Let's begin with the intervention coming from the Vice President, where he says, questioned the rationale, behind judges earning lower than lawmakers. Than federal legislators. Do you agree that, just give us a picture of what remuneration and welfare is like for the judiciary in Nigeria?
Well, I guess that question is directed at me, whether I agree. I think to say I agree is an understatement because, and I'm not surprised that that is coming from the Vice President, because ever since we've known him, he has been a prophet of change, and he's always an advocate of the well-being of judicial officers, as attested by his tenureship as Attorney General of Lagos State, where many jurisdictions have to copy and admirably pick what Lagos State was doing during his time, both in terms of improving the standard of adjudicative responsibilities and that of advocacy within the Ministry of Justice, etc. So when he speaks about remuneration being a startling or an appalling situation in relation to judicial officers, I am not surprised, and those who know him well will not be surprised that it is coming from his lips. And I am exceedingly happy to hear that this evening. I very much agree with that, and I'm very happy with that. And I understand the yardstick he had already set down. I have no reason to depart from that. I agree absolutely that the pay packages of the respective judicial officers, both state and at federal level, should go in line with the various angles or the perspective he had positioned the clamor for the improvement of judicial officers' pay packages. I absolutely agree.
Lordship, well, thank you for that start. The bar and the bench have been conferencing, in the last 2 days on ways to improve the judicial sector, which, has come under great criticisms of corruption, some ineptitude, bringing down the reputation of the bench. Would you want to address the issue of appointments and promotion, at the bench? And what is it like when you evaluate this for us?
Oh, thank you so much. And the question squarely falls within a terrain that I'm very much familiar with. And I wish to say that a lot of people make negative comments, exhibiting ignorance of what it takes to have appointment of judges. Briefly, as you have said, no judge, no head of court on his own can start appointment of judges without convincingly, in his application to the chairman of the Judicial Service Committee, or the Supreme Court of Nigeria, NJC specifically, that he has the caseload to take care of the judges when they are appointed. 2, other facilities that will facilitate their working upon appointment. Now, it doesn't stop at applying. When you get the approval as a head of court, then you embark on advertising the fact that you are appointing so number of judges. Now, along the way, many people that make this outcry, making negative comments, they do not understand at the time of making that advertisement, quite a number of states are already represented in his court. So the number he wants, in most cases, are to reflect those areas that are not represented, or they were represented, but because of elevation to the Court of Appeal, looking at the trial courts, or Court of Appeal to Supreme Court, the intendment of that application or advertisement, which he has to send to all states of the Federation, the heads of court of the entire Federation, he has to communicate to them through a circular. The members of the bar will also be intimated through the same circular from the Attorney General of the Federation and members of the state at the state and at the federal level. Now, after that, you will find the entire country applying, even when their states are not part of those to be considered. And the noise making will start, discrediting the whole very system. Now, let me continue. After getting the applicants left, right, top, and the center, the Judicial Service Committee at the state level, or the Federal Judicial Service Committee, as the case may be, will sit down and consider the list, shortlist the candidates. With regard to the state, they forward the list to the National Judicial Council after the candidates might have gone through screening by the SSS, the EFCC, ICPC, and other investigatory agencies. And while at the agency, a committee specifically dedicated for interviewing these candidates will subject them to interview to see their intellect, to see their comportment, and whether there has been satisfaction of the necessary geopolitical zone that are concerned with that exercise. And after that rigorous exercises, the names are either forwarded to the governor of the state for appointment through the state assembly, or at the case may be at the federal level, the list now sent by the NGC to His Excellency Mr. President, where it is a case of the Senate going in respect of heads of court, they will still have to go to the Senate to face the Senate committee for the purpose of their appointment as a respective heads of court. I'm trying to be as concise as possible so that the hint as to the transparency
actually, Your Lordship,
the process
yes, Your Lordship, I'm very sorry to cut in here. Maybe very briefly, the criticism really is that judges, kind of influence their children of being appointed judges too. That is the complaint from the bar, is the complaint, from the Nigerian public. Why is that so?
Judges appoint their children as judges. Fair enough. I have heard such criticisms, and it's rather regrettable. At a platform of my colleagues with whom I graduated from the law school, this topic came recently. I couldn't resist making a comment. I said, well, I think we should start thinking of making a position, even by legislation, if it is feasible, that anybody who is a judge and has children, they should not be allowed to be enrolled into any faculty of law, to read law, and come back, grow, and to come to start thinking that they have a passion, they want to follow their instinct to become judges or judicial officers, because circumstances of birth have excluded them from being judges, so that right from onset we should not allow them to go and read law. But meanwhile, as I said, a general in the army already has his son as a captain in the army, so in the Navy, so in the police, other paramilitary, and a lawyer, young lawyer practicing. He becomes a senior advocate of Nigeria. His ambition is to see his son become senior advocate, and there are a lot of them with their children there as SANs, or their sisters, or their wives. And meanwhile, when their children are there making money as private practitioners, they have attained that feat. The children of those judges are there as magistrates, posted to rural areas, under harsh conditions, on pittance of salary, pay packages. And now they have risen to the point where they will become high court judges. It is at this point some members of the bar will start shouting that their own children are blocked. And if equity is to come in, the person that has indicated interest on the job and is competent demonstrates, in my view, earlier enthusiasm to belong to that cadre of public service.
Okay,
Your Lordship, all these years, you have gone, and then you can't. Let me land on this.
Great, go ahead, please.
Yes, I cannot see how he can be deprived, because by constitutional provision, nobody can be excluded from pursuit of his civic right by virtue of the circumstances of his birth, because their parents are judges, and you say they cannot, by that reason, they are excluded from becoming judges. Having risen, they have been allowed to go and read law. Some of their parents don't even want them to be judges, but they want it. I have seen that situation as a head of court. And therefore,
if I may come in very quickly.
Not deprive the private bar.
Yes, indeed. Would you say then that there is a nexus, a link between the remuneration of judges and allegations of corruption within the judiciary? Only today we hear stories about lawyers influencing judges and, to issue conflicting court orders, especially on political matters. What do you have to say about that, briefly?
Well, am I to take it that we are now off the issue of appointment of judges and the grudges being expressed by members of the public, or the transparency of the process, which I've already alluded to? I will now go to the question you have addressed, that lawyers have been influencing judges to make conflicting decisions on political matters. Recently, I had cause to address this somewhere. Even the Supreme Court, the Court of Appeal, perhaps by inadvertence, come up with conflicting decisions on the same subject matter. And trial judges are bound by the decisions of the appellate court. So where in a situation, Judge A comes across one of those conflicting decisions of the appellate court, he is properly right to comply with that. In fact, he's duty bound to do that. And if Judge B, on the same subject matter, has a similar decision from the Court of Appeal on the same subject matter, conflicting one another, and he puts to use that decision, he is absolutely right. In such a situation, people will start shouting that, oh, it is a compromise. It is not compromise. It is because of deficit of infrastructural needs that will facilitate speedy circulation of decisions from the appellate court down the ladder, which makes it impossible to understand, even amongst themselves, from one division of the Court of Appeal to another, having to know that so-so decision has been taken by a particular decision of the same coordinate jurisdiction. That's the appeal division called divisions of the Court of Appeal. And therefore, the judicial officers down are bound by such decisions, except if anybody is going to tell me palpably with evidence that, oh, it is an issue of corruption, not the fact that there is compliance with conflicting decisions for which they are bound by from the Court of Appeal. I think I should rest my case on this. I don't want to go further.
Absolutely, Your Lordship.
So
that's a very good place for you to hit the gavel there. Justice, retired Justice Isaq Bello was the Chief Judge of the Federal Capital Territory. Thanks for joining us on News.